Resham versus State of Karnataka and others, 2022, SCC OnLine Kar 315. In this case, Honorable High Court of Karnataka held that prescription of school uniform is constitutionally permissible. In last part, we have discussed question 1, that is whether wearing of hijab is an essential religious practice in Islamic faith. In this part, we will be discussing question 2, that is whether prescription of school uniform is not legally permissible as being violative of petitioner's fundamental rights inter alia guaranteed under Articles 19, Clause 1, Subclause A, that is freedom of expression, and 21, that is privacy of the Constitution. Counsel for the petitioners argued that there is no such power to prescribe a uniform under the Karnataka Education Act 1983. To answer these arguments, Honorable Court first discussed the origin of concept of uniform. Honorable Court said that the concept of uniform is not new. It is of ancient origin. It can be traced to the ancient Gurukul days, and in England, the recorded first standardized uniform can be traced back to the days of 1222, that is Magna Carta days. Further, Honorable High Court explained or discussed the purpose of uniform, the purpose behind the uniform. For this, Honorable High Court referred to a paper by Mark Hill. It is stated, and I quote, by insisting upon identical clothing often from a designated manufacturer, it ensures that all school children dress the same and appear equal. Thus, differences of social and economic background that would be evident from the nature and extent of personal wardrobes are eliminated. The basic purpose behind prescribing a uniform or a common dress code is it eliminates whatever social or economic background a person is having. If everyone wears same dress code, then it becomes very difficult to identify the social background or the economic background of the person who is wearing the same dress code. Further, counsel for petitioners argued that prescribing a school uniform pertains to domain of police power. Court countered this argument and said that in a civilized society, preachers of education are next to parents. Teachers exercise parental power over the students. To strengthen this view, Honorable High Court referred to TMA Pai Foundation case at paragraph 64. It is stated, and I quote, the teachers are like foster parents who are required to look after, cultivate, and guide the students in their pursuit of education. Honorable Court also referred to Old English case in Rex versus Newport, in which it was held that the father of the boy, by sending him to the school, authorized the schoolmaster to administer reasonable punishment to the boy. So by these sources, Honorable Court gave a view that teachers exercise parental power, not police power over students. Further, Honorable High Court said that the government has power to prescribe uniform under Karnataka Education Act 1983. Court reads the section 7, subsection 2, clause G, subclause 5 of the Karnataka Education Act 1983, which provides for promoting harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of woman. Further, court read the section 133 subsection 2 of the 1983 Act, which vests power in the government to give direction to any educational institution for carrying out the purposes of the Act or to give effect to any of the provisions of the Act or the rules, and that the institution, be it governmental, state aided, or privately managed, is bound to obey the same. This section, coupled with Section 7, subsection 2, clothes the government with power inter alia to prescribe or caused to be prescribed school uniform. So, by these readings, under the said Act, the government has power to prescribe for school uniform. When discussing whether prescription of school uniform excluding hijab violates various fundamental rights, the court said that the prescription of dress code for the students, that too within the four walls of the classroom, as distinguished from rest of the school premises, does not offend constitutionally protected category of rights when they are religion neutral and universally applicable to all the students. Further, court said that this apart, it is impossible to instill the scientific temperament which our constitution prescribes as a fundamental duty vide Article 51A Clause H into the young minds so long as any propositions such as wearing of hijab or bhagwa are regarded as religiously sacrosanct and therefore not open to question. Further, court said that prescribing dress code serves constitutional secularism. For this, court referred to the Ismail Faruqi case, and it is stated, and I quote, in a pluralist secular polity, law is perhaps the greatest integrating force. So, how many diversities are there? How much religious diversities are there in one classroom if everyone wears one and same uniform? If everyone wears same uniform, then it is the best way to integrate the diversity into one class. Further, petitioners argued that the wearing of hijab does possess an expression protected under Article 19, Clause 1, Subclause A, and has the substance of privacy, autonomy that are guarded under Article 21. Further, learned advocates appearing for them vociferously submit that the Muslim students would adhere to the dress code with hijab of a matching color as may be prescribed, and this should be permitted by the school by virtue of reasonable accommodation. If this proposal is not considered to, then prescription of any uniform would be violative of their rights availing under these articles as not passing the least restrictive test and proportionality test. Further, court said that all rights have to be viewed in the contextual conditions. The fundamental rights have relative content and their efficacy level depends upon the circumstances in which they are sought to be exercised. However, the petitions we are treating do not involve the right to freedom of speech and expression or right to privacy to such an extent as to warrant the employment of these tests for evaluation of argued restrictions in the form of school dress code. By the test, court is meaning proportionality test and least restrictive test. Further, court stated that schools are qualified public places, and such qualified spaces by their very nature repel the assertion of individual rights to the detriment of their general discipline and decorum. Further, court said that by prescribing same dress code to everyone, how there can be the violation of equality, because there is equal dress code for everyone, equal and same dress code for everyone. Article 14 and 15 cannot be violated when the dress code is equally applicable to the students regardless of religion, language, gender or the like. Further, court said that qualified public places like schools, courts, war rooms, defense camps, etc., the freedom of individuals as of necessity is curtailed consistent with their discipline and decorum and function and purpose. Further, petitioner argued that a classroom should be a place for recognition and reflection of diversity of society. Honorable Court rejected this argument and referred to Regina versus Governors of Denbigh High School, in which it was observed, it is stated, and I quote, "The school's task is also to promote the ability of people of diverse races, religions, and cultures to live together in harmony. A uniform dress code can play its role in smoothing over ethnic, religious, and social divisions. A uniform dress code, a same dress code for everyone, can help in smoothing the divisions between the people." This was the message of the court by this referring. Petitioner's side referred to a case, National Legal Service Authority, and argued that dressing is a part of expression under Article 19(1)(a), which is protected. So hijab is an expression. Court admitted it. Court said it is true that dressing is an expression under Article 19(1)(a), but in paragraph number 69 of the same judgment, that is National Legal Service Authority, it is stated that this right is subject to the restrictions contained in Article 19, Clause 2 of the Constitution. Further, court said that this is not desirable, to say the least. It is too far-fetched to argue that the school dress code militates against the fundamental freedoms guaranteed under Article 14, 15, 19, 21 and 25 of the Constitution, and therefore the same should be outlawed by the stroke of a pen. Further, petitioner's side argued that Kendra Vidyalayas, which is controlled by the central government, are permitting students to wear hijab or headscarf. Then why not the headscarf or hijab should be permitted in state government schools? Court rejected this argument for two reasons. Firstly, that if such arguments are accepted and if hijab is permitted in the uniform, then uniform ceases to be uniform. There shall be two categories of girl students, viz. Those who wear the uniform with hijab and those who do it without. That would establish a sense of social separateness, which is not desirable. It also offends the feel of uniformity which the dress code is designed to bring about amongst all the students regardless of their religion and faith. And the second reason was, court said that what the Kendra Vidyalayas prescribe as uniform dress code is left to the policy of the central government, as being of kind of federal structure. The federal units, namely the states, need not toe the line of center, meaning thereby whatever central government is having uniform in Kendra Vidyalayas, state government need not to follow those uniform. It's up to the state government what uniform they should prescribe for the welfare of the students. After this discussion, court held that in view of the above, we are of considered opinion that the prescription of school uniform is only a reasonable restriction constitutionally permissible, which the students cannot object to. After reading these discussions, we can sincerely draw a conclusion, a very simple conclusion, that uniform is a very cloth which is for the purpose of eliminating the differences between the people who are wearing that uniform. Whatever may be the differences, whether that difference is of ethnicity, religiosity, economic background, or any other differences are there. All the differences are eliminated when one uniform and same uniform is worn by every concerned person.